Welcome, everybody, to this online training session based on Hope for Children through Climate Justice, which is a brand new resource that you may perhaps have seen featured in recent reports in the Guardian newspaper and on the BBC. This manual on legal tools for climate justice, focusing on the role of financial institutions, is published by the World Council of Churches, a fellowship of Christian churches in some 120 countries, representing over 500 million people globally. WCC has been calling for action to prevent climate change for 40, perhaps close to 50 years. But the sad reality is that the only metric that matters, the rate of greenhouse gas emissions, is still going in the wrong direction. So in recent years, we have explored more assertive ways of trying to galvanize the urgently needed action, especially using the logic of following the money and addressing the role of banks, pension funds, and other financial actors in continuing to finance the fossil fuel industry that is driving the whole world to an existential precipice. And often it is our money, yours and mine, that is being used to accelerate this crisis. There's been a proliferation of public interest litigation addressing climate harms and environmental degradation recently, often led by children and young people, as well as elderly people and other concerned citizens. We have been inspired by their leadership, and this manual is designed to encourage more people around the world, in our member churches and beyond, to make use of these legal tools and processes to help drive things in a more positive and sustainable direction. Fundamentally, we are motivated by our deeply felt responsibility to children and to future generations of life on this planet to do everything we can with all the tools at our disposal to protect and sustain this living planet for them. I want to encourage you all to respond to the 1-minute survey that you will see at the end of this session, which will help us improve our outreach and content for these and other purposes. So please do invest that time for 1 minute to complete the survey at the end. This session is going to be recorded for further distribution and publication, so please bear that in mind. And finally, I'd like to encourage everyone to use the chat function to introduce yourselves by name, organization, and country. And then finally, I hand over to my colleague, Frederique Seidel, who serves as WCC's Senior Program Lead on Climate and Children. Frederique, over to you.
Hello, everyone, and thank you so much for joining our online training. I'll tell you a little bit about the why. Why did the World Council of Churches develop this new handbook? And why do we do this training for you? Here on the image, you see 3 teenagers in a lawsuit which they have initiated. One of them is from a member church, and it was several of these children who told us, it is so frustrating. We are sacrificing school time. We are doing so many things to prevent further CO2 emissions, to stop the climate emergency. But you know what? As long as you adults continue fueling the climate crisis through your banks and pension funds, it feels almost in vain because you are fueling the root causes of the global warming. At that time, we had just received the so-called Keeling Curve Prize, which has allowed us to develop a lot of advocacy resources, equipping children and churches for environmental protection as a child protection measure. But we listened to what they said, and we looked at which are the churches which are actually paying attention to what their money does. You may recall we did a few webinars on this before. So we did, for example, this Cooler Earth, Higher Benefits manual, which shows how everyone can protect children by talking to their own banks and pension funds, engaging with your financial service providers. And we got a lot of feedback from children and youth themselves. They said, it's really great, and it seems WCC cares about children, but look at the facts. And here on the image, you see a girl whose name is Eliane Wanjiku. She's from Kenya. She asked me, can you help us, children from churches, meet with President Macron? Because he's organizing a big summit in Paris, Global Financing Spec Summit. We need to talk to him. And she was referring to the so-called Banking on Climate Chaos report. I encourage you all to look it up. Every year, it shows you what's happening. And right now, we know that over $6.9 trillion were invested into expansion of fossil fuels since the adoption of the Paris Agreement. I won't get into the details, but basically we managed to have that meeting between the children and Emmanuel Macron, but no concrete results from the leadership so far. What really worries these children and youth and often keeps them up at night, many of them describe really nightmares and anxiety, because science says that there is enough fossil fuel out of the ground for the transition into renewable energies. For example, the International Energy Agency has documented that very well. We know that over 75% of the greenhouse gas emissions are caused by fossil fuels. But then the reality, which young people find very difficult to then cope with, is that all the opposite is happening to what should happen. For example, the amount of dollars invested into activities that are harming nature amounts to $6.9 trillion. And the investments by our pension funds and banks into nature-based solutions only amount to about $200 billion. That's documented by UNEP. So that's why we did move into a new arena, going beyond advocacy and the resources which actually you will find in the chat box for pure advocacy. But then we reached out to the International Criminal Court, and we urged them to address the current impunity of climate disinformation, which is often aggravating the wrong decisions when it comes to climate. And we made a submission to the upcoming environmental crimes policy, asking to make it possible to hold accountable those who continue financing fossil fuel expansion and who actively, consciously promote climate disinformation. Yes, you've probably seen it all around the media. There are more and more young people themselves who go to the courtrooms. And some of them are super successful. Like here, the young people in Montana, US, they have won. And you might find they look very happy and cheerful on the photo. But I've spoken to several of the plaintiffs. And the reality is, many of them describe how this has really spoiled their entire childhood. Many of them gave up their hobbies. They couldn't enjoy it anymore. They felt every second they have to do something to prevent the worst from happening, which would be that the planet would become uninhabitable for them and their future generations. There is so much hope on the horizon, because as you will hear in the next intervention, the legal landscape is amazing. There are game changers out there, such as the General Comment 26 of the UN Committee on the Rights of the Child. There are many ways to use the law to simply protect the right to life, the right to a healthy environment. But many churches don't know that. Many people of goodwill don't know that. The lawyers themselves are not the ones who are going to be plaintiffs. We need to build the plaintiffs to simply protect the right to life of children and young people and everybody in communities. So one who you all may have read about and heard about in the past, Archbishop Desmond Tutu, said it very well. People of conscience need to break their ties with corporations financing the injustice of climate change. You will find all the information on this link, which we will also share in the chat box. And it is my great pleasure to now hand over to someone who is really amazing. His name is Harj Narullla. He is a barrister from the UK. He's really one of the best worldwide. And many people tell me, but how did you get him? And actually, well, he just said yes when we asked him to advise the WCC in this project. So Harj is a distinguished climate lawyer. He collaborates with Oxford University and the London School of Economics, focuses on climate law and indigenous rights. Harj recently represented the Solomon Islands before the International Court of Justice. So over to you, Harj.
Great. Thank you so much, Frederique, for the very kind and somewhat undeserved introduction. It's a pleasure to be here with you all today. So my job is to just talk about this question of how the law can actually help to address the climate crisis. So I'm going to do that by speaking about three topics. Firstly, I'll set the context for the role of litigation in the context of legal efforts more generally to drive accountability in relation to climate change and to spur climate action. And then I'll talk specifically about some of the types of cases which are happening worldwide and which can be filed if organizations are interested in doing something about climate change. And then I'll finish with a few different case studies just to bring some of those categories alive and set us up for a discussion. So starting with that first topic in terms of what is litigation and what is climate litigation in the context of other legal efforts. So the law can be useful in relation to driving climate action or creating accountability for climate damage in a number of different ways, many of which you're probably familiar with. So the first is domestic legislation. Most countries now have what are called framework climate change laws, so a Climate Change Act, which will set out the steps that a government needs to take to reduce emissions, to take adaptation measures to respond to climate change. And these are very detailed legal instruments which have, in most cases, been around for quite a long time. And they provide the legal blueprint and the regulatory framework which can guide both governmental action, but the action of non-state actors, so corporations, as well in terms of addressing climate change. That's a very kind of functional area in which law is operating. Second one is international agreements. So the one that you're probably all familiar with is the Paris Agreement and the UNFCCC. The Paris Agreement was signed in 2015, and it was the first time in which the world had come together and agreed a temperature goal in terms of trying to reduce global warming to a certain level, and created a framework by which states could make commitments to reduce their individual emissions and also support one another, in particular developing states, to reduce their emissions and adapt to the impacts of climate change. So obviously the Paris Agreement was a huge landmark moment, but it also exists within the context of other international legal instruments. It's not just about the Paris Agreement. Some of you will probably remember the Montreal Protocol, which was set up and created to address the ozone hole, and that was targeted at a very specific sort of greenhouse gas emissions called short-lived climate pollutants and hydrofluorocarbons, which were basically driving the ozone hole. That's generally held up as an example of sort of best practice when it comes to international environmental law and treaty making. And just that agreement alone and the world's transition away from HFCs, hydrofluorocarbons, has been estimated to have reduced warming by about 0.5 degrees, which is a lot. So there are a range of different international agreements outside of the Paris Agreement, which are applicable to climate change from areas like the law of the sea, human rights law, and so on. So for lawyers who are looking to use litigation, we can draw on these different international instruments for international cases and regional cases. So we have domestic legislation, international agreements, which is like a form of international legislation. And then the third part of this picture is litigation. So this is obviously going to the courts in both contentious and advisory disputes to try and get certain types of outcomes. As I'll come on to in a bit later today, there are a lot of different types of litigation, but the one that we are speaking about principally here is strategic litigation, which is trying to use specific cases to achieve a systemic or strategic outcome. So it's not necessarily about winning in the individual case. It's about maybe trying to change government policy, trying to create precedents which can maybe change the behavior of corporations and other actors. So you're trying to have a systemic effect by filing certain types of litigation rather than just winning the case in front of you. So one of the reasons why litigation has become quite popular and prominent as a legal intervention to address climate change is because of the fact that it offers this opportunity to bypass deadlocked political processes. So what that means is essentially when you have governments that are refusing to take action in the other branches of government, so in the executive and in the legislature, you can still, in countries where you have a functioning rule of law, go to the courts and try to compel the government or other actors to change their conduct. So it's something that's detached from the political cycle and who happens to be driving the policy agenda, which I think is very empowering to communities who file cases, different institutions, NGOs, faith groups, and so on, if they're wanting to drive action and don't want to wait around for governments to take the initiative. So that's part of the context for why litigation is an area of strategic focus. I think it's just helpful to reflect on the role that litigation has played in history in terms of successful social movements. So if we think about the civil rights movement, the movement for women's equality, tobacco litigation, these are processes which are a multitude of different legal and social and political processes, where litigation plays an enhancing role, where it's building on civic pressure, public pressure, and provides an opportunity for legal norms to shift in concert with those other movers. So I think it's important to think about litigation as being integrated with campaigning, being integrated with systems change and policy change, rather than something that sits outside of those different processes. So if you're a person or an individual or an institution that is trying to change systems, then litigation is a very effective tool when working in concert with campaigns in particular. Just in terms of how climate litigation has been sort of growing. As I mentioned, the Paris Agreement in 2015 was a real landmark moment because it created real obligations for countries in relation to climate change. Since 2015, we've seen a 70% 70% of all climate cases have been filed since 2015. And there have been about 2,700 cases that have been filed to date. That clusters in certain geographies. So most of the cases we've seen to date have been filed in the global north, so in Western Europe, in the US, in Australia. But we're starting to see a growth of strategic cases in developing countries and in the global south as well. And there's a lot I can say about different types of climate litigation and what's behind those different geographies, but the sort of basic reason for why most of the cases are in the global north is because that's where the majority of the problem is in terms of the large emitters. So trying to stop corporations and governments from emitting high amounts of greenhouse gas emissions, it makes sense to file in those locations. But there are lots of climate cases which are not just about mitigation, so reducing greenhouse gases, but are also about things like adapting to the impacts of climate change, making sure that communities are supported in those adaptation measures and climate resilience measures. And that's a lot of what we're starting to see in the developing world as well. Okay, so that was just some context for why litigation is important and how it fits with other legal interventions. I'm just going to give hopefully a quick overview of some of the climate litigation strategies which are effective and quite well established now. So just starting with domestic legal strategies, I've broken them out here into public law and private law strategies. Public law cases are cases where it's individuals or groups or faith organizations against the government and is seeking to change governmental behavior. So the classic example here are human rights or constitutional claims, which are brought on the basis of human rights and constitutional protections, which the government is responsible for adhering to and maintaining. And these have been some of the most successful climate cases. So basically arguing that, at least in the case of Agenda, which some of you might have heard of, that the government has human rights obligations which include taking action on climate change, and failing to take that action is a breach of citizens' human rights. So administrative law claims are similar but slightly different, and they are using public law to challenge executive decision-making. So this could be things like challenging the planning approval of an individual fossil fuel project. So saying that the permit was wrongly decided, or the environmental impact assessment did not sufficiently take into account the greenhouse gas emissions associated with the project, and therefore the project should not go ahead. This is sometimes referred to as a whack-a-mole approach, so fighting individual projects rather than trying to systemically change government policy as a whole, which is often the intention of human rights and constitutional cases. Administrative law cases which are focused on an individual project can have systemic impacts. So one example here is the Finch case, which was a case in the UK, which came from the Supreme Court last year. And that ruled that basically the scope of environmental impact assessments, what I just mentioned, needed to take into account all of the oil and gas that would be burned as a result of an individual project. And when weighed in the balancing exercise of whether or not you should approve a project, it's very difficult to justify an oil and gas project when you take into account all of those different emissions weighed against things like the social and economic benefit from the project. That case was successful. So it's an individual case, but it's had a systemic effect now across the UK in terms of stopping other fossil fuel projects from coming forward. The next 3 points here are examples of what are called soft law complaints. So these are or mechanisms which are different to litigation, where you go to court and you have sort of the typical advocacy that you normally think about. And these are basically mechanisms where you have different types of dispute resolution. So, for example, OECD complaints are using the field of business and human rights law to say that individual corporations and businesses have breached human rights obligations that they owe to communities. And filing a complaint, an OECD complaint, has a lot of benefits compared to litigation because it's much more cost effective. You don't have the risk of paying the costs for the other side. Doesn't go for nearly as long, and it provides an opportunity to bring the different actors together around the table to have a negotiation, basically about what the outcome should be. The UN Guiding Principles on Business and Human Rights, similarly another framework, and you can make complaints to an international body under those principles. And then the third one here is talking about regulators taking action. So this is slightly different to the normal model of a community or a faith group or individuals bringing a case, but it's asking the government itself and government regulators to take action against actors that you're wanting to target. So some cases you might have heard of in this area are in relation to greenwashing, where different regulators have gone after different companies for what they say is misleading consumers in relation to their products. So those are all domestic strategies which are using public law, so law against or in relation to the government, to drive action on climate change. Come on to now the private law actions, which are between private entities. An example of this is, which I'll come on to in a bit more detail later on in the case study, is a shareholder action. So this is where shareholders in a company can bring a legal action against the company itself for breaching some of its duties. Another one is a consumer-led greenwashing claim. So customers of a particular business, bringing a case against that business by saying that their conduct has been misleading in some way. Or tort claims, which is saying that basically an individual corporation or entity owes a duty of care to another individual, and that individual has been harmed by the conduct of that corporation. So this private law area of climate litigation is one that is growing. There's a lot of attention on the idea of communities, institutions, individuals suing, for example, fossil fuel companies to try to get them to pay for the damage of climate change flowing from their emissions. Those sorts of cases haven't yet been decided or successful, but I think that's just a matter of time. And there's been a lot of focus on corporate climate litigation, which is focused on the obligations of the people who run corporations and making sure they're adequately addressing climate change. I'll just quickly go through some regional legal strategies and then maybe give you one case study. I'm just mindful of time, and then we can jump into the Q&A. So I've just been speaking about domestic options, so public law against governments, private law between two private entities. I'll very quickly speak about regional and international strategies. So this is going to regional courts, which are some of the popular sort of venues are the European Court of Human Rights or the Inter-American Court of Human Rights. Is a regional human rights courts where people can appeal to them if their domestic courts have not given them the outcome that they want. And there's been a lot of climate litigation in these courts in recent times, particularly focused on human rights issues. Similarly, you've got the CJEU, which is the regional court for the EU, which has application again to a large number of states. It's not the same scope as an international court, but it still has wide application to a range of different jurisdictions. In terms of international legal strategies, there are 3 simultaneous cases before international courts that are dealing with climate change that are very consequential. I'm very happy to talk more about them, perhaps in the Q&A. This is before the International Court of Justice, which is the World Court. There was a case last year with over around 100 countries making submissions. It's the biggest case in the court's history. I worked on that case, and that was all about basically what do countries have to do under international law in relation to climate change. So we'll get that decision at some point this year. And I think we're very likely to see more climate litigation, both at the international, regional level, but especially at the domestic level off the back of these international decisions. One thing I'll mention is what is a sort of an international version of soft law complaints. So these are complaints to international human rights bodies, which again have the benefit of being quite cost effective. They don't have a particularly complex procedure. And there have been some examples of complaints by different groups, particularly representing Indigenous communities or children, to the UN Committee on the Rights of the Child and the UN Human Rights Committee, where there have been successful decisions or helpful decisions on climate change from those bodies. So these are not courts as such, but they are bodies which are able to receive complaints, particularly in relation to violation of human rights. Okay, so hopefully that's a useful whistle-stop tour across different types of climate litigation strategies. And as I said, I'm very happy to jump into a bit more detail in the Q&A. I have some case studies, but I'm mindful I'm at time. So Frederique, would you like me to do one of these, or should I
Yes,
hand
just
over?
one. Thank you.
Okay. So Frederique's mentioned Held in Montana, so I'll maybe leave that one. Let's talk about McVeigh and Rest, which I think is a really interesting example of how climate litigation can achieve outcomes even if you don't make it to court or you don't win. So this is a case brought in Australia by an individual who brought this case against his pension fund. And he basically said that the pension fund was not disclosing relevant information related to climate change, basically saying that they were exposed to a range of physical transition risks connected to climate change, and they needed to disclose information about those risks to their shareholders. This is a really interesting case because after they filed, they obviously made a range of requests in that case, and they managed to achieve essentially all of the things that they were seeking from the litigation before the case even went to trial. So the company changed its behavior. They started collecting the information that the claimant was requesting. They started disclosing it. And then the whole pension fund industry also changed its practices off the back of this, because there was essentially a shift in what the new standards were in relation to climate change related disclosure. So ultimately the case settled because there was no reason to go to court. So it was very cost effective. You didn't have to go through litigation, and there was a big drive, a shift in behavior across the pension fund industry in Australia and also abroad. So I think this is a good example of how very strategic litigation, which is focusing on sensitive intervention points, can drive outcomes, which doesn't necessarily require you to go through the whole rigmarole of going through court. So hopefully that's a useful example to sort of get you thinking, and very happy to pick up any questions. Thank you so much.
Thank you so much, Harj. And before we move to the questions, I want to emphasize how that last point was so important, because we do receive many offers of support at WCC from people who tell us, if you can let us know which members of WCC or partners are planning to do legal action about which financial institution or company, we will make sure they do change their policy before it even gets to the courtrooms, because nobody wants headlines in the media about their company being sued by organizations which stand for moral values. So this last example shows how this can happen very quickly. The results can happen before it even reaches the courtroom. Thank you so much, Harj. And I see there is already one question for you in the chat box. How can African children hold the global north accountable through litigation?
Yeah, it's a great question. So there are a lot of different options. I think it depends on the country, the jurisdiction, and the type of case you're wanting to run. As I mentioned before, you've got international cases. So it could be that an example here is of oil spills in Nigeria. As some of you will know, there have been very significant environmental pollution connected to Shell's operations and BP's operations in Nigeria for decades. And there's been quite a lot of litigation at the domestically to try and deal with that against those multinationals, but also in foreign courts. So one area of law is transnational environmental and climate litigation, which is what I'm describing, where you have a community in this case Nigeria bringing a case in the UK against the UK headquartered company and applying Nigerian law to that company, but in the UK. These sorts of cases are quite common in the context of environmental pollution. In the context of climate change, they're relatively novel, but there are starting to be more of them. So that's one option, is transnational litigation. As I said, domestic cases which are targeting global north actors who are operating in that jurisdiction is another option. That could be a human rights case or a private law case, or complaints to international bodies. So the point I finished on in relation to the UN human rights committees, that could be a route as well if you're wanting to make a complaint against a foreign state for the extraterritorial impact on the human rights of people in Africa. So yeah, it really depends on some of the specifics of which African children, which global north states, and so on. But there are a lot of different options to explore.
Thank you very much. I hope, Lise Müller, this answered your question to some degree. Now a question from Richard Stobart, who's saying, sometimes legislation is approved and becomes law, and then never enforced. In the UK, there was a citizens' assembly on the topic of sustainability, but the recommendations were never taken up by the government. Can non-implementation be challenged?
Yeah, I think this is a wonderful question. And I think it speaks to some of the limitations of law. I think it's really important that people understand that law is not a silver bullet, litigation is not a silver bullet. For a problem as big and complex as climate change, no single intervention is going to be able to address it. This is just one tool amongst a broader toolkit of strategies that need to be used. The law, as this question indicates, has its limitations, particularly around enforcement, and you are relying on the strength of the rule of law in particular countries, or the international rule of law if you're thinking about international courts. Enforcement is one of the main issues that I think non-lawyers focus on, but I think it sometimes misunderstands the indirect ways in which law can be powerful, even if it's not necessarily being enforced. So an example here is the McVeigh case, right? So the one I just gave you, that example I gave you, there was no court judgment there. No one was bound to do anything as a result of those proceedings, but you saw a shift in behaviour from the entire pension fund industry as a result of filing litigation, so crystallising legal risk. So law operates in a way that is subtle and indirect, and not always through binding and enforceable judgments. So even if you have a binding and enforceable law which is not being adhered to by all actors, it'll probably change the conduct of a large group of actors, and that, I think, is a step towards the type of outcome you want. So you're always going to have problems with enforcement, but my view is that it doesn't mean that these tools or strategies are unhelpful. It's just about sort of pricing that in and being thoughtful about the limitations of what you're doing.
Thank you very much, Harj. And there will be time for more questions, and I'm noting all those which couldn't be answered yet. But first, we will hear from Sister Susan François. Sister Susan François is based in the US, in New Jersey, and represents the Sisters of St. Joseph of Peace. Over to you, dear Sister Susan.
Thank you very much. It's an honor to be here and to share our story. Hopefully you can see my screen there. So we are engaged in what was just shared there about shareholder actions as an institutional investor. Just to tell you a little bit about the congregation, we were founded in England in 1884, so we're 141 years old. This is our founder, and our purpose has always been to promote the peace of the church, both by word and by work. We are presently located in the United Kingdom, in the eastern United States around New Jersey, and the western U.S. Near Seattle. And we are just about 100 sisters. So this is a story of how we can make an impact no matter how large our organization is. What I'm going to tell you is grounded in our faith foundation as Catholic sisters. So in our constitutions, which are approved by Rome, we name explicitly that it's important for us to use our resources to reverence the blessings of creation. And as sisters who take a vow of poverty, we share our resources and to use those to work for a more just society. We have been active in the area of environmental justice and climate change really since 1990. Every 6 years, we gather with our delegates to elect our leadership and to direct our direction and how we live out that gospel of peace. And in 1990, at our chapter, the theme was One Creation, One Future. And we began to look then at corporate actions that could lead towards ecological soundness. My first chapter as a new sister was in 2008 when we had a chapter act explicitly on care of creation and climate change. And two commitments we made then, which are relevant to this story. One was to stand in solidarity with those on the margins who were already impacted by climate change, and then to collaborate with others. And then that led us in 2016 to develop our land ethic, which is on our website if you're interested. But these are the principles of our land ethic, and especially relevant to today's topic. The fifth principle there is the principle of intergenerational justice. We say that we have a fiduciary responsibility to Earth and to future generations. And then we were delighted when all of this work fit into the larger framework of the church. Pope Francis, many of you may know, issued an encyclical named Laudato Si. And in 2021, we, the congregation, committed, along with many Catholic organizations in many sectors, to implement the 7 goals of the Laudato Si action platform. And the third goal specifically is to foster ecological economics, to recognize that our economic power and influence and impact cannot be separated. In fact, is intricately linked to our ecological impact. And then, even more delighted when a few years ago the Vatican issued this document, Mensorum Bonum, for faith-based measures for Catholic investors. And what I'm going to talk to you about right now really fits into this framework of how those of us that have a faith motive can and should be using our investments. And it's a large document, but one element is they outlined the call to engage, to vote, which is what we're going to talk about here as shareholders, to voice, to be in dialogue with corporations. And back in the fall, I believe in the UK, there were 70 Christian organizations that voiced their concern with UK banks on their climate financing, and our congregation was one of those. And then also to exit through divestment. And back in 2022, our congregation did fully divest from fossil fuels and were part of a global announcement that I was delighted to see. The World Council of Churches was part of that. There were 35 organizations in 7 countries that announced that divestment then. But we are still invested in banks, which is why we're here today. So the story I was invited to share is our shareholder advocacy. And while it's newer that we're doing this in the area of climate financing, we have been engaged in shareholder advocacy back since 1975. Our first statement was with Palmolive, which is a soap company, about the gender bias in their ads. We have a particular concern for women. And many religious organizations, including Catholic Sisters, were involved in shareholder advocacy in the anti-apartheid movement. We continue to be engaged, always in partnership through the Interfaith Center for Corporate Responsibility, and then 2 coalitions we are a part of, Investor Advocates for Social Justice here in New Jersey, and the Northwest Coalition for Responsible Investment out in Seattle. So as shareholders, we have legal rights to file proposals at annual general meetings, and we also engage in dialogue with corporations. All of this to share our concerns with other investors about the regulatory, legal, and reputational risks to the company. We are committed to working with impacted communities, those marginalized persons, to share their experience and to amplify their voice. And we do this as faith-based investors, but we appeal to all people of goodwill and all investors, making the faith-based business case of common sense, good business, and ethics. And as faith-based investors, as Catholic Sisters, we seem to have a great deal of influence, and we've been told by our partners that when we are at the table, the corporations listen differently. So the specific example I was invited to share is with one bank, Citibank, that we are the lead filer, and it is particularly focused on Indigenous human rights in financing of oil and gas projects. So we have filed a similar resolution for the past 3 years, and it has a simple ask that the bank publish a report evaluating its effectiveness in respecting Indigenous rights. And the purpose of this really is to let the company and the investors know, to have an eye on how their own commitments to human rights, if they are implementing them and preventing harm, or if there are gaps in the policies that expose the shareholders to material risks. Now, 1 in 4 shareholders, investors of Citi, have agreed with us each of these years, which is a pretty significant result in a shareholder proposal process. And not only do the voters of those shareholder rights, at least a quarter of them agree with us, perhaps the biggest impact is, and this was mentioned earlier by Frederique, that companies don't want to see their names attributed to something, particularly if it's someone with a moral authority that's recognized. And so, as you can see from these headlines from across the world, this story over these years has caught some attention. Sisters are very persistent, was one of the quotes that was in there. And so it's a way that we as religious people can share our influence. Now, after the 3rd year, Citi did issue a report called Respecting the Rights of Indigenous Peoples. Unfortunately, they did not consult with any Indigenous peoples in the drafting of this report. And in general, the impacted communities did not feel that it was sufficient. And really, as investors, neither did we. Of the 16 companies that were flagged in the report as posing risks, none had been refused finances by Citibank. This was their own reporting. And of the 37 projects which they identified as posing a risk to Indigenous rights, they only refused funding to 7. So we and the communities we work with did not feel that this was sufficient to the request of a quarter of the shareholders. And so we filed the proposal again this year. Now, Citigroup then filed what is called a no action letter, claiming that they had done what the proposal had asked, so we shouldn't have a right to file it again. And we are very persistent, and so we went back to the Security and Exchange Commission in Washington, and were delighted last month when they actually agreed with us. And the quote in their ruling was that it appeared that their disclosures do not substantially implement the proposal. And I believe Frederique is going to send a link to this article from the Religious News Service that talked about this win in the chain of events that is still unfolding. So at the end of the month, this woman, Olivia Bisa, who is the first woman president of the Chopra Nation in the Amazon, will present our proposal on our behalf. In concert with our commitment to standing in solidarity with impacted communities, the past 3 years, we have had an Indigenous person present the proposal for us at the Citi AGM. Also, just to note that while we are the lead filer on this proposal, the Maryknoll Sisters, the Sisters of St. Francis of Philadelphia, and United Church Funds are co-filers with us, just as we are co-filers on a resolution that United Church Funds have with Wells Fargo. So it is an ecumenical effort that we have here. And the reason why President Olivia Bisa is going to present is she is very concerned, as are her people, about not only the environmental impacts of financing of climate projects in the Amazon, but also the human rights impacts. And just some examples here of oil spill that happened in October to give you a sense of the scale. Just in the Amazon in the past 20 years, $2.3 billion have been financed by Citi in oil and gas activities. And there's great concern about a pristine heart of the Peruvian Amazon that Citi projects are looking to finance development of, and the lack of UN-recognized free, prior, informed consent for Indigenous persons. So that is why we are partnering with her. And this quote of hers, I think, just helps us to see why this is so important. She says, "We, the Indigenous people of the Amazon, have lived through ecological devastation, witnessed decades of pollution, and faced repeated threats to our self-determination due to spills caused by oil companies like Petroperu and their financiers such as Citi. So we are sharing our influence with her and her people to raise awareness. And that is just to end here before we have time for some questions. What is possible was what I was invited to discuss. Now, we did get a report. It didn't fill the needs that we wanted. The financing is still happening. To me, perhaps what is most important is that we are using our voice and sharing our influence to raise awareness and affect change. Even outside of the US, this press has gone national and international. And so the more that we can share those stories and raise that moral question is most important, I think. And then in the theme of that Vatican document, Mensorum Bonum, collaboration and maximizing our influence is what is most important. We, as faith-based investors, those of us who are here for a faith motive, collaborating with those of any faith or no faith, but who are also socially responsible. And so this is a story in progress, but I hope that you will continue to follow along and see what happens at the end of the month. And perhaps we will have even more than 1 in 4 shareholders fighting with us on this. Thank you very much for listening.
Fantastic. Thank you so much, Sister Susan, for your perseverance, which is so much needed for tangible hope for children, and for giving this powerful example to inspire others to follow your lead. And it's true that now there is not so much time, but we will have a part at the end where further questions can be raised, and also about everything you shared. A suggestion would be that now we go straight to Nicholas Young, who is from the Oxford University Climate Research Centre in the UK, and who will speak about steps to taking legal action. So helping you to think through a bit more in practical ways how you could consider developing a legal case. Go ahead, Nicholas, over to you.
So I'd just like to
Go ahead.
reiterate what Peter said at the beginning of the call, and that is to make sure that you fill in the survey that we provided shortly, because we are gathering expressions of interest and are keen to better understand which groups will be interested in potentially pursuing legal action and what your particular circumstances are, because this is an ongoing discussion. So make sure you fill in the survey. And the second thing I would like to say is that there are many, many more resources about climate litigation provided at the end of the handbook in the appendix. So please go ahead and look at those. And if you're keen to learn more, I'm sure you'll gain a lot from those resources, because this is increasingly, as Harj was discussing, an area which is growing across the world. More and more cases are being brought, particularly by young people. So there are a lot of terrific examples to draw upon to guide our way forward here. Okay, so with those 2 points reaffirmed, I'll just now talk to you briefly about some of the general steps that we can take if we're thinking about legal strategies or litigation. And I suppose to answer the question, what can I do if I am interested in pursuing this path? So I'll just share my slide with you all now. Okay, so as discussed, climate litigation is one of several ways in which individuals and groups can seek to achieve climate justice and respond to the climate emergency. But climate litigation varies significantly in nature and form. So there's no kind of one strict series of steps that you should necessarily take in pursuing litigation. But there are kind of 4 general steps that we advise in the handbook. And the first of which is to understand your legal basis and standing in bringing a claim. And so by that, we mean if you're considering bringing a case, you need to understand how the government or corporation which you are considering suing has contributed to the harm that you're suffering. So, for example, they may have caused a particularly high amount of emissions leading to an exaggerated or worsened natural disaster in your region. And then what you perhaps should do is look to similar examples of people bringing cases like this. And you can find examples like this in the materials provided in the handbook, as well as the case studies in the handbook. Secondly, it's important to build a strong support network. So we advise that you do speak to lawyers as early as you can to better understand the kinds of claims that you're likely able to bring. But in addition to speaking to lawyers, so solicitors or barristers or attorneys, if that is the language that's used in your jurisdiction, we advise reaching out to groups such as NGOs and advocacy groups like the WCC and others who are engaged in climate litigation and public interest law matters. And we also suggest, if you're considering bringing a claim that involves more evidence of a scientific or economic nature, reaching out to climate scientists. I know many of them at Oxford who are engaged with litigants across the world, bringing in these kinds of actions. And oftentimes there is climate science which is not being used, which should be being used in these cases. So engaging with climate scientists is an important aspect of this. And I'm more than happy to refer people to such scientists if that would be of assistance. The next thing is to then gather the evidence. So presuming that you've been able to kind of develop a case theory, the next step that you would go through would be to gather evidence which proves the harm which you're alleging or proves the breach of the obligation, etc., which you're alleging, and linking that to specific actions or inactions of the defendant. So you're using your credible scientific data to clearly define what the problem is and what you're seeking in response. So it's really important with litigation to focus on the solution you're seeking, start with the end in mind, and ensure that the order that you want from the court is front of mind all the time when you're proceeding with the case. Because at the end of the day, that is what the judge or judges will be most concerned with. What are you evidencing? What evidence are you providing? What do you say happened? And what should I, as the judge, do about it? And lastly, and as will be discussed in the next section, there's an important role here for engaging publicly and trying to promote and raise awareness through media and campaigning. Because as Harj mentioned, there are many different impacts of climate litigation, and even promoting climate litigation or climate change as an issue which should be of more concern to people and an issue which is worthy of greater political engagement is an important impact of climate litigation. So where appropriate, consider trying to publicize and make some kind of advocacy around litigation to help enhance the impacts and provide a greater level of overall impact for the case. So with that, I'll pause there and hand back to Frederique for questions.
Thank you, Nicholas. And we have many questions in the chat box. I will just start with one, which is on the how to protect oneself from counter litigation by the companies, such as the use of the so-called SLAPs, the strategic lawsuits against public participation, which are intimidating or silencing advocates. Can it be a discouragement? Or so what is your recommendations on this?
Yeah, this is a great question.
Go ahead, Harj.
Oh, sorry, Nick. Yeah, so I think it might have been mentioned in the chat as well. There's a very high-profile example recently of a case against Greenpeace. I'm on the board of Greenpeace, so I've been quite close to this one. And there are a few different things that are happening both at the legislative level, but I think that steps that you can take to try and reduce the risk of SLAPs. First, I'll say the EU has passed anti-SLAP legislation recently, which provides a number of procedural protections for people engaging in litigation. So when a SLAP suit is filed, that new legislation creates a power for laws to rapidly dismiss any SLAP suit, so a case that's sort of not brought in good faith. It also has a framework for providing compensation to defendants. So say it is Greenpeace being sued, Greenpeace would be compensated due to that new legislative framework. That's going to come into force in the EU, I think, in May of 2026. So that will extend to people within the EU. In terms of ways to mitigate threats, though, I think it's some of the steps that Nick was talking about, being thoughtful about the jurisdiction that you're litigating in, making sure that you're picking the right target, so the type of corporation that's unlikely to sue you back. It's really only a handful of corporations that I think are willing to risk the reputational blowback and the reputational cost of actually the optics of suing a group. Thinking about what it does to a company's reputation to be suing, for example, a faith group for them trying to, in good faith, take action on an issue such as climate change. It's only a small category of companies that would be willing to actually do that. So being thoughtful about target selection. Then I think it's about things like limiting sort of cost exposure and the ability for them to countersue. So it depends on the jurisdiction that you're filing in again, but the type of case that you bring has very different implications for the amount of exposure to the financial risk. And then I think it's simply a matter of there are other kind of steps that can be taken, such as insurance, the structure of the claim. So the entity that is bringing the claim can be maybe one that's set up so that there's less liability for the institution, the people who are standing behind it. There are a number of different measures that can be taken to basically reduce the risk upfront. So it's a big problem, but I think that there are measures that can be taken to mitigate the risk. The final thing I'll say, though, is that I think the examples that we have rightly get a lot of attention, but it is still very uncommon. And as I mentioned before, there are 2,500 cases, climate cases that have been filed. You don't have SLAP suits filed in relation to really any of those. It's only a very small handful where you've seen these sorts of cases being filed. So I think the risk is relatively low, and you can take steps to mitigate that risk as well.
And
Thank you very much, Harj.
If I can add into this just real quickly.
Go ahead.
Obviously, I'm over here in the United States, and we are having a major shift in our geopolitical reality here, also in this space as well. And so last year there was a accusation over 130 organizations that were part of an anti-woke climate cartel. So we can't deny that that's not real. But I think what is important is that we as gospel-based people of faith are at the table and offering our voice, because we do have moral authority. And if we are involved, perhaps there's less of a chance of those kind of risks happening. So the risk is there, but I think it's even more of a reason why we need to be involved.
Thank you, Sister Susan, and thank you, Harj. I would like to add that since we have started this initiative, I have received a tremendous number of offers of support from partners and wealthy people who are so happy to see the churches building their capacity in this field that they told me those which have issues with such SLAPs, well, there was a fund also for that. And there's a number of people who have asked to know which churches or partners are planning for which case, and they will help with backup. So that's one. And I also want to say we do capacity building for all, but by May, June, we will select among all the expressions of interest one for which we also have then the financial backing support. So what we need from you participants now is proposals for ideas and what cases you would like to pursue, and we will help with the pragmatic aspects and the risk management. There will be more time afterwards for some discussions and questions. But first, I would like to give the floor on the topic of campaigning alongside legal action to my dear colleague, Reverend Jackie Makena. She is a clergy of the Methodist Church in Kenya and vice moderator of the World Council of Churches Faith and Order Commission. She will present together with Kevin Maina, who is the team leader of the Young Theologians Initiative for Climate Action. And he is also commissioner of the WCC Climate Justice Commission. Over to you, Jackie and Kevin.
Right. Thank you so much, Frederique, for that. I'll be looking at the campaigning strategies to support legal action, especially for faith communities. There are four strategies that we can use as faith communities for cascading the information to the congregation and people at the grassroots. We start with the contextual Bible study, then there is pulpit messaging, which is about sermon, then worship integration and becoming potential allies. Contextual Bible study, to explain briefly, is a communal, participatory, and critical approach to reading the Bible, which invites ordinary people to reflect together on their lived experiences in light of the scriptures. And in contextual Bible study, we seek to make Bible or sacred text relevant to real life issues by placing the communities and, in our case, environmental realities at the center of the interpretive processes. When we go to pulpit messaging, here we're talking about sermons. And it is good for me to say that a sermon is not just a review of sacred texts, but it is a dynamic message that speaks directly to current issues. And in the context of climate litigation and climate justice, sermons should clearly articulate how God's word, calling us to be stewards of creation and defenders of oppressed, transforms into a call for engaging in legal action for environmental protection. So we can use that strategy to create awareness and also to reach as many people as possible with the information on climate litigation. Then we go to worship integration. This is to enhance our worship services with thematic elements. We can include responsive readings and prayers in our worship, in our liturgies, that is incorporating the sacred passages that speaks of environmental justice to guide in the liturgy. Another way we can do this is structured justice moments within the liturgy. Here we can dedicate a brief portion of the service, such as maybe immediately following offering or after communion, to focus on the themes highlighted in the handbook. And talking of liturgies, we can see a good example from the Anglican Diocese of Edmonton in Canada, who have come up with a liturgy to mark Earth Day, which will be actually next week on Tuesday, immediately after Easter. And this is a sample liturgy of how we can create our liturgies to incorporate the issues of climate justice and climate litigation, which is backed by scripture, because there's no contradiction between climate litigation and Christian values. Then also we can become, or faith communities can become potential allies. Faith communities are not meant to work in isolation. Our calling as faith communities includes joining the broader networks that work for social transformation. And when it comes to the issue that we're talking about today, collective action has far more impact. And this can be done through holding cross-generational dialogues and community engagements. An intergenerational mix ensures that fresh perspectives from young people, who are often at the forefront of climate activism, are balanced with the wisdom of elders who can provide historical or other details and the context of what we are talking about. With this, also we can, in the area of becoming potential allies, we can hold joint prayers, webinars and advocacy, which creates opportunities for the congregation to learn from experts in both legal advocacy and environmental policy, thereby demystifying the legal process and reinforcing its moral legitimacy. And I'll give an example with the Juliana versus US case, which exemplifies faith communities as allies in effort of climate justice. And in this case, 21 youth who are aged between 10 to 21 years are suing the US government for its contribution to climate change and its failure to protect their rights to life, liberty, and essential public resources. And their actions call for a moral reckoning in the nation, urging people of faith and conscience to unite in solidarity. And in addition to this call, they have called for a more than 1,000 climate justice centered summons. So these are types of collaborations and practical ways that faith communities can use to demystify or debunk the climate litigation information and information of climate justice in general. And at this juncture, I'll invite my colleague, Kevin Maina, who will take us through the summary of the handbook and highlight more things on campaigning. Kevin, please, welcome.
So, colleagues, in helping you to become allies, as highlighted by my colleague Jackie, we have some campaigning tools we can use. And among them, I developed these highlights from the handbook so that you can have a quick to-go resource when you need to share about this with potential plaintiffs. And this can be either individuals or the decision makers in organizations. So on this page 1, we begin with the definitions of strategic litigation. We go to the primary causes of greenhouse gas emissions, and also a note on how children suffer most, but lack the political power to drive change, like us who have. And you can see from this page 1, we have inclusion of Bible verses that you will see on all pages. And this is to signify of how our faith calls us to accountability. And moving on to page 2, the flyer shares about the urgency of the climate crisis and why we need climate litigation to accompany the various forms of advocacy that we are all, I believe, involved in one way or another. We also have a highlight on the aim of the initiative of why we should be involved in strategic litigation and why the focus is on the financial actors as well. And as I move to page 3, we begin with a diagram. We begin here with a diagram of the initiative. We begin with a diagram on the ripple effect of climate litigation and how it achieves systemic changes at various levels. And this shows you how this change can come even without only being in court. And you can see from pro-climate behaviors, public awareness, among the others. Still on this page, you will also be directed to the handbook, where you'll find suitable legal strategies depending with your context. And it also shares on the general steps you need to observe when engaging in climate litigation, and some of which has been shared by Harj and Nicholas earlier on. Finally, still on this page 3, there's an image with a quote, and it highlights on the urgency to act now by calling for accountability. And under it, you'll see a QR code where you can download the handbook and the other accompanying resources like this flyer that I'm sharing now. And I hope we can all see this page and the QR code as well. And you can type in the chat your comment about the quote, and you can also do a quick scan of the QR code to access the resources that are there. On the last page, we finish with a call to action. And this is with whatever avenues that you have at your disposal and with the knowledge that you have gained today as well. And further to it, you can see an email down here. And if you'd like to pursue a case at your context, kindly get in touch with the team. And now, even as we are going on, and for follow-up right after this call. And finally, just to ensure that we all have a way to participate in this initiative, there'll be a link shared by Evas or the comms team that has social media cards that we can use to post on our social media platforms and accompanying hashtags as well. And thank you all, colleagues, for this and for joining in the call. And I'll hand it over to Frederique.
Thank you very much, Kevin and Jackie. So you've seen, for those who may not yet be comfortable to develop a legal action proposal themselves, there are many other ways through campaigning to make a big difference. And I would like to also highlight that Kevin and Jackie are those who helped anchor the handbook in theological reflections. So this is a very important part of conveying the message to the WCC members. But this resource is as much for Christians as for others. And while we were preparing it, many leaders from other faiths were saying, but our sacred texts say exactly the same. So we have decided to do a multi-faith version in the next step. Therefore, any participants from other faiths who want to collaborate in that, please send us a message. And now I would like to open the discussion on anything you've heard where it has triggered some thoughts, ideas which came to your mind, or further questions. And I would like to ask you, Peter, if there have been questions which you think should be highlighted in this part of discussion, please let us know. And also participants can ask for the floor if you would like to share your question by speaking to everyone. And then my colleague can unmute you and give you the floor.
Thanks, Frederique. Among other questions that have come up in the chat box, I think the most recent one does pertain to this question of campaigning alongside legal action. More specifically, it focuses on whether public engagement in the form of boycotts of corporations and investors from the public, especially in developed countries, could be a useful adjunct to and support for litigation strategies, and could the church play a role in this? I'm not sure who among the speakers is best placed to respond to that, but I was thinking perhaps Sister Susan might have thoughts on that, as well as perhaps others.
Certainly. I was delighted to see that campaigning was part of the presentation, because really that is our biggest impact, I think, of setting the stage for these actions. If we can raise the moral issues and mobilize the people to understand how we are connected, how Pope Francis talks about how one of the greatest crises that we have right now in our world is a globalization of indifference. And so if we can globalize our connection and our support of these efforts and our real concern for the future and for climate, it will only make the cases have a greater ground on which to reside. So any efforts that we can do on this campaigning, I think, is going to have as much, if not more, of an impact than the legal cases will, in a sense, because it's in the court of public opinion that we will shift the tide. Not that we shouldn't also do the legal things, but in our case, the impact we've had has been much more because people have raised awareness and joined their voices with us than the actual legal wins.
And there was another question I noted, Frederique, that was actually responded to in the chat box, but it has to do with the strategy of perhaps retaining shareholdings in specific companies, precisely for the purpose of being able to exercise the right to speak in shareholders' meetings. And Sister Susan already responded to that in the chat, but I think it's something that it's worth highlighting maybe in this discussion session right now. I don't know, Sister Susan, do you want to speak to that again?
Sure. Just what I said in there, it has to be your own discerning, what is the risk. Now, in most cases, until the laws change, you don't have to have a huge share. And what we've done, so for example, we divested from fossil fuels directly. That means we lost that opportunity to engage directly with energy companies. But we felt that just wasn't for us worth the moral risk of being directly contributing. And yet we still hold banks. And so we're using that avenue there. So I think it's not a black and white answer, but I think every community of faith needs to look at what their threshold is for risk and what their potential for influence is, and make the choice that makes sense for them.
Thanks, Sister Susan. Back to you, Frederique, and to the other speakers.
Thank you very much. And I would like to also use this occasion to remind of the image of the mustard seed, which is so important for this project, because in the world context of today's poly crisis, many people are finding it really difficult to cope and to also manage the eco-anxiety. And I think really what we see is that legal action is the best remedy for eco-anxiety. And the feedback since our launch and offers of support have been so overwhelming that I can really see how there's something happening here. And it may also have to do with the spirit in which we have developed this project. So lawyers usually use the word against, but we at the WCC, as you may have noticed in the handbook for those who already read it, we don't use that word against. This project is not against anyone. It is about the banks, pension fund, or any others for financing fossil fuel expansion. And we have amazing examples like the former oil company Harj, which went completely from black to green without dismissing any employee. They recycled all their skills. And so this project is really about creating a livable future for children. It's for tangible hope for children, but it's not against anyone. And therefore, I think it is really flourishing. And you're all encouraged to look at all the details. And remember, we have the opportunity to accompany and support one case, which will be selected by end of May, June. And in addition, all the others, we will matchmake with all these people who offer support. So don't hesitate to choose one of the options. And you will see in the handbook there's one which is indicated with a finger to show you the easiest options. So you really have a range of a menu from very easy, very simple, with no risk, to more complex. Choose the one which suits you most. And if there are any questions for Harj and Nicholas, who are the lawyers who continue accompanying us in this process and who will be helping to develop the strategy to be accompanied by WCC, let us know, because they are still online. So any questions you have always wanted to ask a specialized lawyer, this is your time. And if not, then I would hand back to you, Peter, as there's a few points still to share before the conclusions. And there will be also some time then to fill in the survey.
Do you mind, sorry, Peter, to interrupt, just to pick up on Frederique's sort of invitation there, and just to maybe speak to what it looks like to develop a case with a lawyer. One of the useful things about this handbook is it will give you a good sense of possible legal avenues, but ultimately that's someone like me, that's my job, right? And I work all the time with different communities that have a problem, whether it's, an oil spill or a polluted river, and they don't know what the legal remedy is, what the legal options are, and they come to people like me, come to solicitors, and we work with them to try and figure out a solution. So it might be that you are part of an organization, a faith-based organization, or you see a particular climate-related problem in your community that you feel passionately about, but you don't know what the legal options are. That's totally fine as a basis to reach out to Frederique and other colleagues. And then we're very happy to work with you to try and figure out if there's a case there and what that can look like. So please don't feel like there's any sort of barrier to entry. The starting point is having an interest and a commitment to doing something, and then we can take it from there. Thanks, Peter.
Thank you, Harj. And I see a question from Liesel Müller. Would you like to take the floor, Liesel, and give a quick intro to yourself and ask your question yourself? Because I think the work you do is amazing and people should know you also and see you.
I'm a litigator here in South Africa with the Centre for Child Law. We were an amicus curiae on the African Climate Alliance case. And I can tell you that it is actually just yesterday, leave to appeal has been granted to go to the Supreme Court of Appeal. So there's more to come on that case. but I'm also doing research on child-led cases, and my question is about the trend that we're seeing that children's cases are being dismissed for admissibility, very strict procedural rules on whether their issues can be redressed or whether they've exhausted local remedies. I'm just curious to know whether the lawyers have any insights on how we can overcome these strict barriers, which perhaps might need to be adjusted through a child rights lens from the.
Just before I hand over to you, Harj, I would like to say the spirit of the WCC's project here is that we do want to take the heavy burden away from children and ask adults to do this. But we will collaborate with children and youth who are already suffering from eco-anxiety and who want to do it. But we don't want to go to any child who is having a lightheartedness and still a good childhood to tell them to do litigation. So this is how we do it, but we will consider doing it with children and youth when appropriate. So over to you, Harj, for any answer and comment.
Thanks so much, Frederique, and thanks, Liesl, for that great question, and congratulations on the leave to appeal. So yeah, I think it really depends on the jurisdiction, right, and the type of case you're filing. I think if we want to talk about the European Court of Human Rights decisions around admissibility when it comes to and just context for those who are listening on the call who aren't lawyers, what we're talking about here is basically who has the right to bring the case to court. And Lisa was asking about some decisions which have basically been saying that children in certain cases don't have the standing, so the right to bring the case to the court, and therefore you don't even get into the detail of what their claim is. It's dismissed on those procedural grounds. One of the key decisions from the European Court of Human Rights, a regional human rights court that made decisions in 3 contentious cases on climate change last year, was to constrict the legal framework for who can bring cases to essentially organizations and individuals, but only in quite narrow circumstances. So to answer your question, Lisa, I think it's about looking firstly at the jurisdiction, but thinking about how you're constructing the claim. Maybe it makes more sense rather than a group of individuals or an individual child to bring a case, you bring it through an association, potentially in the European context. So yeah, it's a case-by-case approach, but I think there are ways around it. But we also need to tackle those issues head on and fight them and try and widen the precedents back out.
Thank you, Harj. And just some heads up, as there are many here who are from the African continent, we will have a governing body meeting in June in South Africa. And in that context, there will be another hybrid seminar on this handbook. So more to come on this on our webpage. And now over to you, Peter, for the closing and conclusion.
Thank you very much, Frederique. Well, I'm going to be brief. I simply want to stress a few important takeaways. And that is that, as Frederique has mentioned, we are embarked upon a process right now where we are looking at proposals from our constituency, from our member churches, but also from partners around the world, with regard to possible cases that could be supported as emblematic pilot cases for this type of engagement. So we really want to encourage you to have a think about, what this sort of approach, climate litigation in your context, might look like, and to suggest cases that you think should be considered for this initiative. We are being supported by a specialist foundation for the purposes of providing that sort of technical and legal support to a test case in this domain. So we really want to encourage you to submit your proposals by the end of May, if not earlier, better earlier, to the email address that I think has been shared in the chat box, and maybe one of my colleagues can share it again, so that we can consider your proposals. And we really hope that this introduction to the manual has provided you with some inspiration and some tools to help formulate those proposals that you will submit to us. Because the idea is that this should be a resource and an initiative that is led less by the World Council of Churches in Geneva and more by a global constituency of faith-based and other actors who see a role of this type for them. Now, we want to close with something very special. because first of all, I want to direct you to introductory page 7 in the guidebook. You may have seen it. This young lady, Faith Sebwa, was the youngest member of a WCC delegation to one of the climate COP meetings in 2023. She's 13 years of age and she's deaf. But she was inspired to write a poem that has been published now in the introductory pages of this handbook. And then, as soon as the handbook was released, we received a proposal or a communication from a musician in the UK who had created a tune, a melody, to which this poem could be set. We're still working on a production that brings the words and the music together. So we don't have that yet, but we do have the melody. And so as we close, we're going to play that music. But finally, don't forget, we need your feedback in the survey that is being provided. The link is provided in the chat box right now. This is your responsibility to help us by completing this survey. It's 1 minute. It won't take long. Please complete it. And as we close, listen to the music to which Faith's poem will be set.
La, 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 la.